Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath, and we're talking about reverse discrimination. And in particular, we're talking about a U.S. Supreme Court case called Ames v. Ohio Department of Youth. In the big scheme of things, it's a relatively recent case, and it has what we think are some broad-reaching impacts that employers should be thinking about and employers should be aware of. It touches on this concept under Title VII of discrimination claims and what happens when you have someone bringing a discrimination claim who is in what we think of as a majority group. So it could be a discrimination claim brought by a man, a discrimination claim brought by someone who's straight, a discrimination claim brought by someone who's American. These are all the types of things that come to my mind when we think about what would typically or traditionally maybe have been called reverse discrimination. So we're not talking about a discrimination claim, for example, by a woman claiming gender discrimination, or someone from another country claiming national origin or race discrimination. So this is a little bit of a different concept than the typical Title VII discrimination claim. And I think it's worth thinking about because as we head into 2026, we are seeing more and more momentum from courts to a certain extent and the EEOC on allowing these reverse discrimination claims. So we want you to be aware of that, and we want to just unpack that a little bit. So I know Doug has been looking at the Ames case this morning, doing a little refresh. Doug, tell us a little bit about the facts in Ames and some of the key things that you think employers would be interested in learning about.
Sure, Pam. So this case had to do with a heterosexual woman who worked for the Ohio Department of Youth Services. She got interviewed for a new management position, but another candidate was hired, and that person happened to be a lesbian woman. And at some point, Ames got demoted to a different role, and her role was filled by a gay man. And then she brought this case claiming that she'd been denied promotion and demoted because of her sexual orientation, and brought that to the district court. And she lost at summary judgment, and the agency won. And in that case...
So hang on before you go any further. So her sexual orientation, she was saying, was as a straight woman.
As a straight woman, she felt she was discriminated against, both in promotion and because of this demotion. So then what happened is her at the district court, she was she lost at summary judgment because she had not established these background facts that showed that she was the rare majority group plaintiff that had suffered discrimination. And she appealed and went to the Supreme Court, and that's what we're talking about today.
Okay. So my understanding is that some federal courts, not all, but some federal courts had required, in the case of a discrimination claim brought by someone in a majority group, for them to have an additional showing in order to meet their claim with certain background facts or certain factors that made their case more persuasive. So some courts were requiring a higher threshold of proof for people in a majority class. And Ames, somewhat on appeal, decided whether or not that was something that courts could require or not.
Yeah, exactly. So this happened in the Sixth Circuit. The Sixth Circuit was one of these circuits that had that additional pleading requirement, or basically it said or additional evidentiary requirement that basically said that there were two different ways that majority employees could meet this burden. They could either show that someone from the minority group made the employment decision in question, or they could provide some evidence that there was a pattern of discriminating against majority group employees. So there's kind of two different ways that they could do this, but this was an additional requirement that if you were in a minority group, you didn't have to meet.
Okay. Jennifer, what do you take it from here? What were some of your thoughts on Ames?
Well, I know before we started, what has, from the very beginning when the Supreme Court issued this decision, I think certainly kind of mind-blowing for lawyers, but for anyone who kind of follows the Supreme Court, especially in recent times, this was a 9-0 decision, which means all justices were in agreement as to the outcome in the case. And, that just hasn't happened very much, I would say, especially on, a lot of cases of this nature, right? We're more accustomed to seeing 5-4 or 6-3 decisions. So I do think it's notable that on this one, all justices of the Supreme Court agreed that it was not consistent with Title VII to require some plaintiffs to make this additional evidentiary showing. And, they had some discussion of, typically a plaintiff has to make what's called a prima facie showing, right? I am a member of a protected class. I suffered some adverse employment action, and I have something that indicates that that occurred because of my membership in the employment class. And, the regular requirement does not include this additional burden of having to show additional facts and circumstances. And the court does comment that, Ohio really didn't have any good explanation or reason for why this additional burden, additional showing should be required or was properly required under the text of Title VII. So it is now gone, right? Cannot be required any longer. All plaintiffs who are claiming discrimination, including harassment under Title VII, are now held to the same standard of proof. So, I think generally speaking, that is going to make it a little easier for plaintiffs out there to bring claims, and for some employers maybe seeing these quote-unquote reverse discrimination claims, there's no longer this additional argument to make that they haven't met this burden. So, just a different playing field, I would say, once you actually get to litigation. Everyone's in the same boat. Same standard applies to all plaintiffs. If you're in a protected class, that's what you have to show. Adverse action, some causal connection between the two, essentially. There's a little different standards for different kinds of claims. But and I think for reasons that we're going to be discussing, this is becoming increasingly noteworthy, and we're seeing it scattered across a lot of different areas of the law right now, and seeing things that are happening over the EEOC that are consistent with this general trend that the world of people who can bring claims, who are being invited to bring claims of discrimination under Title VII is I think, getting larger.
Yeah. I know I personally have had a hard time getting my brain around the fact that under Ames, it seems like everyone is in a protected class, because if you're trying to identify who's in the protected class, really there's an argument now that everybody's in a protected class of some type. So I think that's a bit of a mind shift and something that employers need to be aware of. The world looks different from an employment law perspective in 2025 in light of Ames than it did previously. So as Jennifer touched on, and as you may have heard us mention in some prior podcasts, the EEOC has made several pronouncements in 2025 consistent with this concept of somewhat promoting reverse discrimination claims and encouraging employees to bring them. So again, the Ames decision was June 2025, and as 2025 rolled along, we saw, I think it was a technical bulletin in the fall talking about national origin discrimination claims from the EEOC, and really making it clear that from the EEOC's perspective, Americans should be free to bring national origin claims. And that's a bit of a shift, right? Before, I know in my practice, when I would think of a national origin claim, I wasn't necessarily thinking of people from the U.S. bringing national origin claims, but the EEOC bulletin made it clear they are welcoming claims from Americans asserting national origin violations.
Yeah, and I know, as I think through these issues, it still is the case that whoever brings a claim still has to show that whatever they say happened to them that was unlawful, that thing happened because of the protected class that they're claiming. That being said, I do think employers there is a higher risk of seeing more claims from a larger number of people, and it just might be a little bit harder than it used to be to try to address those claims early on in the litigation process if it gets that far, which I know is not the happiest of news for employers. Luckily, there are things you can do on the front end before you even have a claim coming in the door, right, to try to avoid that happening. But I do think kind of the new reality is that employers could be just seeing a lot more claims of a kind that they aren't used to seeing.
Yeah, and I think it's important to recognize that this case didn't change what's going to happen at trial, right? So the burden of proof under Title VII it did not change with this case. It was the same thing before, afterwards. This really has to do with kind of all the steps to get to trial and whether or not a court could dispose of a claim at an earlier stage. So like Jennifer said, I mean, we're going to maybe see more claims. We're going to see maybe more, higher settlements or something that effect, because employers won't be able to, just kind of discount certain claims and get rid of them early.
Yeah. Yeah, the other EEOC communication I was thinking of, and I know we've touched on this on prior podcasts, but was one from December 2025 from the EEOC chair, basically inviting men to bring claims on the basis of gender or national origin. And again, that would fall into this concept somewhat of reverse discrimination. So we have a U.S. Supreme Court case acknowledging the viability of those claims and saying that it's an even playing field for how those get the burden of proof on those. And then we have the EEOC continuing to evolve with new stuff. So takeaways for employers. What do you guys think are things that if you're an employer listening in, what should you do to make sure that you're tracking with this somewhat new law?
Well, the fact that you're listening is already a great start. One thing that was crossing my mind is, if you're an employer and someone brings a report or a complaint that they feel like they're being discriminated against or harassed in the workplace, and, maybe a white man comes forward and says, I believe I'm being harassed because I'm a man. It might have been all too easy in the past to sort of be a little dismissive of a complaint like that. And I would encourage employers to take that complaint just as seriously as any other complaint. If it needs to be investigated, look into it, treat it like any other complaint, process it through. I think that's just going to be very beneficial, in ensuring that all of your employees feel like they are treated fairly, uniformly under your policies, but also, if down the road you end up in some kind of a lawsuit or a claim, it also shows that you as the employer take these things seriously. You looked into them, right? It just can be a good defense down the line if a claim actually comes to happen.
And this is the point in the podcast where we say you need to think about documentation because
Yep.
because anytime you make some sort of decision that's going to affect somebody's employment, whether it's hiring, demotion, firing, some sort of discipline, you're going to want clear documentation of the reasons for that decision. There may have been times in the past, like Jennifer just alluded to, where you're dealing with a, white, straight, male American, and you might not think about worrying so much about that documentation. Be even-handed. Document things having to do with all your employees whenever it's changing something to do with the terms and conditions of employment. And that's going to be your best defense. That's going to be the most helpful for your attorney should a claim get filed. That's going to make things more efficient, run more smoothly, and ultimately save you money.
Yeah. Yeah. Documentation still is your best defense. That's what, like Doug said, it's still going to come down to, can you show a legitimate, non-discriminatory reason for doing what you're doing? And it's interesting in our training role, I feel like we are getting asked more and more by employers to come in and talk about documentation. Like, what does that look like? How do you know when to do it? What type of things to include, what not to include, and why it's so important. And the reason for that is not because it's the most exciting topic. I always laugh because I'm like, oh, not documentation. It's kind of hard to be really entertaining when you're talking about documentation. But it really is the most important thing that your supervisors need to know and understand. And if you don't have good documentation, it's really hard for us to put up a solid defense. So absolutely, documentation's a big deal. Like I said, training and, these guys have talked about other good pointers. We are hearing out and about from our clients, from other lawyers, that there is an uptick in claims right now. And we've talked about this a little bit before too, but last fall, we were talking with the EEOC and with our Idaho Human Rights Commission director, Ben Earwicker, and they both were saying, both on a local basis, Ben Earwicker with Idaho Human Rights Commission, and on a federal basis, a representative from the Seattle EEOC office, they were then seeing an uptick in claims. And there was a local plaintiff's attorney from Boise on that panel where I was having these discussions with them, and he was saying they can't even staff cases. They're just turning away plaintiffs because so many people are contacting them for legal help. And I would say in the first couple weeks of January 2026, we are seeing a pretty sizable increase in the claims are coming in. There's a lot of claims, and I don't think that's unique to us. I'm hearing that from other lawyers and other clients, other employers in the community. So you got to take action to try to make sure that you've got your house in order and that you've got the right training, policies, documentation, and you're staying on top of these laws and pronouncements from the EEOC, among others, as 2026 rolls along. So that is a good place for us to end our episode today. We, of course, will be watching all this and we'll be on the lookout. I think it's safe to say we'll be hearing more from the EEOC. They now have a full quorum. We've been waiting for a while to see what was going to come next. And I think it will be a busy year and we'll continue to have lots of new info to share. In the meantime, just a reminder that we've got our Law for Leaders book. It's a great desk guide to have there if issues come up. That's available on Amazon. And then we also have our training schedule ready to roll for 2026. We have quarterly trainings. Our next one is called Triple Threat, and that is talking about the intersection between the ADA, the FMLA, and the PWFA, Pregnant Workers Fairness Act. We're going to do a little deeper dive on what that means for employers as the PWFA gets a little bit older and we start to see more issues and claims and maybe some legal authority on what employers are supposed to do with those claims and issues. So check out our trainings. Go to updates.idemploymentlawyers.com/2026 training bundle. I think there's some special pricing if you sign up early and get all the trainings at once. So check all that out. So that's it for today. We'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.